I don't have a problem. You have a problem. Why are you following me?
You want to get arrested tonight?
Arrested for what?
For LMP?
For what's LMP?
LMP?
Yeah, what is that?
You want to find out?
Yeah.
I can take you to jail. So
For what?
You can find out on the airport.
Why? I'm just walking.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. If you're wondering, yes, I am wearing my tribute shirt to Donnie Baker, the late, great Donnie Baker, aka Ron Sexton. If you don't know who that is, do a little YouTube search. Probably give you a smile that you, if you're anything like me, you don't deserve today. But guess what? Donnie Baker always makes you smile. Unfortunately, Ron passed away in, I think it was late last year, and he is dearly missed, and I just happen to be wearing that shirt today, so a little sidebar there. But our video today comes to us from the YouTube channel called Hurtado, and it actually depicts Mr. Hurtado being harassed by West Miami, Florida police officers as he's walking in a public area close to where he lives. Now, shortly after the video begins, Hurtado is accosted by two West Miami police officers, which is a small town adjacent to Miami, Florida, and the following takes place. Now, just as an aside, I have made no edits of this video with the exception of the expletives being muted. However, you should go over to Hurtado's channel, show him support, and thank you for sharing this encounter. Let's watch the video, and then we'll come back and talk about the law.
Yes?
Okay?
I'm okay. Are you okay? Excuse me, what did you say?
What's your problem?
Am I saying f you to you?
What is your problem?
I don't have a problem. You have a problem. Why are you following me?
You want to get arrested tonight?
Arrested for what?
For LMP?
For what's LMP?
LMP?
Yeah, what is that?
You want to find out?
Yeah.
I can take you to jail. So
For
you
what?
can find out on the airport.
Why? I'm just walking.
It's not normal for a normal person to be at 2:50 in the morning.
Really?
Walking around.
Who
Yes.
says? Who says?
law.
You know that law doesn't say that.
No?
No, I'm surprised you don't know the law being a cop. So what are you going to arrest me for? What you're threatening me?
Listen, first things
You're threatening me
first.
with arrest.
Listen,
Yes.
first things first, lower your voice that there's people sleeping and
Oh,
we don't want to cause...
Okay, so what do you want, man?
We're following you
What do you
because
want?
it makes
What
no
do you
sense.
know me? What do you want?
I know who you are.
Then why are you following me?
Because I know who you are now.
But if you know who you are, why are you following me?
Okay, listen.
Because I want to make sure you're not doing anything that you're not supposed to be doing.
Really? Really?
Yes, I'm
And really, have I ever done anything that I'm not supposed to do?
Oh, a bunch of times.
This is the kind of bullshit I can't deal with anymore.
Okay, then
Listen,
move.
Then move.
Yes.
Oh, really?
I already told
Yes.
you once, lower your voice, okay? There's
So
people-
what do you want?
there's-
We're patrolling. We're
What do you
making
want?
Sure, we're
What do
making
you
sure
want?
that everything is fine.
No, you're not. You're not making sure. You're harassing. That's what you're doing.
Harassing?
Yes.
Yeah, subjects.
You're
Like you.
harassing.
Yeah.
Subject, I've never broken the law in my life.
No, you've never been arrested before.
I've never been arrested in my life.
Listen to this guy.
Hey, I've never been arrested in my life. What's your problem? You're telling me I've been arrested? You're telling this officer I've been arrested? You're lying to him because I've never been arrested.
You've been arrested by officer in West Miami a bunch of times.
Listen, you're so full of right now. You're not even funny.
Don't disrespect me.
I'm not disrespect. I can tell you you're full of because you are full of
Listen,
You want to get arrested, I
lower
guess.
your voice.
You really want to go
Oh, you're
for
gonna
the
tase
ride.
me too now?
This is not a taser. This is my handcuff.
Okay, so what do you? Okay, arrest me, bro. What do you want to arrest me for?
24 him.
What are you gonna arrest me for?
24 him.
What are you gonna arrest me for? Huh?
From his information. And
For
because
what?
we're the
I don't
ones,
have to
like,
give him
we-
my information, man.
No?
Listen,
You have to identify yourself.
I don't have to identify myself.
Yes, you do. Because
Especially
it's
that
not
you know me.
normal at this
Listen,
time
let me
to be
lower my voice.
walking
Let me lower my
around.
voice.
And when you saw us, you start going
I
around.
didn't saw us. I saw you.
Exactly. And
So-
then you're trying to avoid
So you're
me.
taking
Why?
out the
Is
handcuffs
that
on me.
normal?
You're threatening me with arrest. Do you think just because you have a badge on you, you can go around threatening people with arrest?
No, I can stop people and find out
Listen,
what are you doing.
Listen.
Why are you
this
walking
is even,
at this time?
This is even, because this is my neighborhood.
Okay, this is your neighbor, but it's not normal to be walking around. I
But-
don't know who you are until now.
No, you knew who I was. You
Yeah,
knew who I was.
from a mile away.
And now that you know who I am, why are you still talking to me?
Because I want to find out
No, because
everything
you,
is
that's
fine.
called, no,
I
that's
want to
called,
make sure everything is
listen,
fine.
Listen, that's called harassment, ¿me entiendes?
That's not.
Okay?
That's not.
Do you know your amendments by
That's
any
not.
chance?
I do.
So you're gonna arrest me? Why?
Okay.
Better arrest me.
listen,
I dare you. Vaya, to
Listen.
arrest me.
Don't fucking dare me.
listen. I already told you.
I will lower my
Okay.
voice. I lower my voice.
Lower your... Okay.
I lower my voice. And why are you
Listen.
coming?
Listen.
This is harassment,
okay,
bro.
can you just
I've
listen
done
real
nothing
quick?
but walk my freaking sidewalks.
Okay,
That's what I'm watching.
Hey,
Everything
keep
is
watching, but
fine.
don't come to me and stop. I'm not even supposed to stay here right now.
Listen, we are...
I'm being nice to you.
Nice.
And we're being nice to you.
No, you're not. He's threatening me with arrest. He's not being nice to me. He's taking out the handcuffs and stuff. I don't want to talk to you guys anymore. What did you say? To go fuck myself? Listen, tú tienes muy equivocado where you work at. You know, you have your, and you even know me. And,
Keep walking, bro.
and you even know me.
Keep walking. I know you. Okay?
What are you gonna
I know
do?
you. I'm full of shit.
What are you gonna do?
Full of
You're coming
shit.
at me like you're gonna hit me.
Full of shit. Get out. Get
Coming
out.
at me like
And
you're
if
gonna
I see you doing something wrong, make sure you're gonna go for the right.
Oh really?
Yes.
Oh really?
Yes.
If you see
yes.
me doing something
if
wrong,
I see you again, because you've been arrested.
if you see,
before for
I've never been
people
arrested, bro. I'm sorry to blow my
people-
voice. I'm
No,
sorry.
no, listen, if you scream
Property.
one more time, you're going
I
to jail
see
for
you inside
disorderly.
people's
I
property
have
before.
never been arrested
No?
in my life.
Go. Keep going.
I can't believe the things that you've done to me. You know, this is the kind of thing that has me not wanting to live anymore in my own neighborhood. You know,
If you don't like it, then move.
if I don't like it, then move.
Get stopped every night if we see you walking around.
I'm gonna get stopped every night.
Yeah, if I see you walking around, yes.
Every night I'm gonna get stopped.
Yes.
You don't deserve to be a cop.
Okay, so you notice that the one thug officer on the left basically starts puffing his chest almost immediately. He asks Hurtado if he wants to be arrested. And Hurtado asks for what crime? And the officer says L&P. Well, L&P is loitering and prowling, which is a specific statute in Florida, and it is what I believe to be an unconstitutionally overbroad statute. I believe it's overbroad because of situations exactly like this, where it gives the officers far too much discretion in whether or not to arrest someone. But the courts in Florida, of course, and at the federal appellate level have disagreed with me and managed to save the statute by clearly defining a couple of separate legal elements in order for a person to be convicted of loitering and prowling. Now again, as it relates to like a Terry stop for reasonable articulable suspicion, it's pretty clear that we don't have it here. You have a person who's walking in a public place, immediately stopped by the police, and there's no real context here. So the only thing we really have to go on is whether or not the Florida loitering and prowling statute 856.021 applies. So here's what it says. It is unlawful for any person to loiter or prowl in a place at a time or in a manner not usual for law-abiding individuals, under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. Now that's pretty broad, obviously, but it goes on. Among the circumstances which may be considered in determining whether such alarm or immediate concern is warranted is the fact that the person takes flight upon the appearance of a law enforcement officer. Well, that would be superseded by whatever the court decided in the Wardlow decision, but anyway, the person refuses to identify himself or herself. Well, Brown versus Texas would disagree with that position. Or the person manifestly endeavors to conceal himself or herself or any object. Now this is the important part. A law enforcement officer shall, prior to any arrest for an offense under this section, afford the person an opportunity to dispel any alarm or immediate concern which would otherwise be warranted by requesting the person to identify himself or herself and explain his or her presence and conduct. No person shall be convicted of an offense under this section if the law enforcement officer did not comply with this procedure. Now, in what I consider to be a serious stretch in order to find a constitutional basis for this garbage statute, the courts have basically boiled down the requirements to those two major elements. In spite of all that legal mumbo jumbo that we just read, the two actual elements that the court have found somehow buried within this garbage statute. Number one, the accused has to be loitering or prowling at a place, at a time, or in a manner not usual for law-abiding citizens. And number two, the loitering or prowling must be under circumstances that warrant a reasonable fear for the safety of persons or property in the vicinity. Now, in addition to the two required elements, you also have the part that's incumbent upon a police officer to allow a person to dispel the officer's suspicion prior to a person being arrested or convicted of this. So let's look at what happened here and see if the officers did what they should do. Well, I'll give you a little bit of a preview. No, they didn't. But anyway, let's walk through it anyway, because that's the purpose of the channel. So for one, we don't really have a lot of context as to what property might have been around, but we can see some cars. And Hurtado does appear to be sort of walking parallel to a sidewalk in the video, so it's unclear whether he's in a parking lot or where he really is. So it is possible, I guess, under Florida law, that being in a parking lot around locked vehicles or closed businesses could satisfy the elements, in that an officer acting in good faith could think a person hanging around a closed business or a parking lot at night might be doing so in a way that threatens property. And it also, according to the first element, might be unusual for somebody who is a law-abiding citizen to be doing that. But let's not forget what we saw in the beginning of this video or get ahead of ourselves in giving the officer the benefit of the doubt here. This officer, first and foremost, kind of tipped his hand a little bit by the way he so aggressively approached this guy. He didn't act like he was conducting any sort of investigation. It wasn't like, hey man, what you up to? It was an immediate sort of escalation into a chest-bumping pissing contest. Now, if you actually do a little bit of research and read Hurtado's comments, it's clear that this officer has it out for him and that they have a history, and that explains a lot. But the law requires something else of officers before they can arrest someone for loitering and prowling, lawfully anyway. As we noted before, the police are required to afford the person the opportunity to dispel the suspicion. Now, this is one of a couple problems I have with this law, constitutionally speaking. Well, first and foremost, we have no obligation to dispel an officer's suspicion because we have no obligation to participate in an encounter with the police. Now, I'll talk more about this as part of my closing, but I don't think any law that requires something that is antithetical to the Fourth and Fifth Amendment can actually be constitutionally sound. The other thing, and this is just me spitting my opinion, but the fastest way to tell if a law is unconstitutionally broad is to watch a police officer like this thug that they've hired in West Miami feel like he can make it fit any situation in which he wants to exercise control and intimidate a person with a threat of arrest. We've all seen it 100 times on YouTube videos, and the most common players are disorderly conduct, obstructing, and apparently in Thugtown, West Miami, Florida, loitering and prowling. But what about the elements to the actual crime here? There was actually an interesting Florida case decided by the 11th Circuit Court of Appeals called Harris versus Wingo, where the court actually stripped qualified immunity from two police officers who arrested a guy named Robert Harris for this same statute, loitering and prowling, in Collier County, Florida. The facts were basically that Harris was seen on a bicycle coming out of a closed storage facility around 9 o'clock, and he was wearing a backpack. Two deputies stopped him and started investigating. He said he was working with a guy who was still in the storage facility, and he actually even went so far as to call the guy and put it on speakerphone and said, hey man, will you come out and talk to these officers and let them know what's going on? Of course, being that the guy was getting ready to dispel their suspicions, the officers took it upon themselves to snatch him off the bicycle and arrest him. Now the court almost did a good job in their opinion in Harris v. Wingo because they started to flirt with the idea that it was silly to think that it was a threat to property simply by a person being outside. They made the statement that they thought it was questionable that simply being outside a closed storage facility with a backpack at 9 p.m. represented a threat to property, but they stopped short of actually going into that analysis, which is a very frustrating thing that they do sometimes, and that's something I'll cover more in depth in the closing. But because the officers didn't actually comply with their part of the law, where they have to give a person an opportunity to dispel their suspicions, and they ended up arresting the guy before his witness or whoever might vouch for him could come out and tell them what was going on, the court said, well, the officers didn't even do what they were supposed to do, so we don't need to even address the issue of whether or not it's actually suspicious to be outside of a closed storage facility at 9 o'clock with a backpack on. And so they decided that their arrest was not only without probable cause, but it was without even arguable probable cause, which again is something else that I'll discuss in the closing. They went on to deny qualified immunity to Wingo and Chapman, and Harris prevailed. And I'll leave a link to the case in the description because it is an interesting read. So in light of that decision and the court's flirtation with suggesting that simply being at a closed place at night is not enough to be considered a threat to property or safety, I don't know how a guy who was obviously just walking around could then be a threat to property where he wasn't looking in any windows, he wasn't trying to hide, he wasn't running away, or doing anything outlined in that sort of convoluted statutory language that would suggest an intent to do something nefarious. And just like the court in Harris versus Wingo, we don't even need to go there to determine what happened here. The officer immediately says, what's your effing problem? Now I ask you, does that suggest a concern that this person is a prowler, or is it a roaming ego territorially pissing on a tree? You see, when I watch the video, what I see is an officer who wants to instigate a confrontation with someone it turns out he actually has a history with. The fact that he immediately says, do you want to be arrested for L&P, and Mr. Hurtado has no clue what that even means, tells me two things. Number one, the officer's way too comfortable with not understanding what's required of law enforcement and with using L&P as a catch-all to arrest anyone they want to arrest. And number two, that if he did have an actual concern that Hurtado was prowling, his preferred remedy was geared more towards proving to Hurtado who was in control of this particular territory than it was towards stifling crime. I mean, that's what gangs do. This is not what well, Let me correct myself. This should not be what law enforcement officers do. The more YouTube videos I watch, I am increasingly convinced that this is what law enforcement officers actually do. They have sadly established themselves as a gang instead of a force for good, focusing on service and protection. If anything in this scenario was being protected, it was territory and ego, not property or public safety. So in closing, one of the most frustrating things that courts do is punt on issues where they don't want to upset the apple cart too much and they can still let the plaintiff prevail. So like in the Harris versus Wingo case, they knew that Harris was right and they knew they were going to give him what he wanted and they were going to deny qualified immunity. What they could have done is they could have called out the chicken shit idea that simply being around property when it's closed is somehow a threat to property and safety, and they could set an actual standard for law enforcement to have to work around and to consider in the course of dealing with people on the street. But instead, they punted. In their discussion of qualified immunity, they went into the standard for establishing qualified immunity as probable cause for arrest or arguable probable cause. Let me pause for just a second for an extremely dramatic eye roll. Arguable probable cause is one of those terms that I could do 10, 30-minute videos on that consist entirely of me screaming and beating my head against the wall because it's such an asinine thing to apply when your decisions have such an enormous impact on people's lives. It doesn't matter whether you rule for the police officer who's going to lose his house because he loses qualified immunity, or you rule for the plaintiff who's going to gain the police officer's house because of the denial of qualified immunity. This stuff matters and it has an enormous impact on everybody's lives involved. So why we would go so low as to suggest that a thing called arguable probable cause is the way that we should decide things is beyond me. That's right, an officer can be granted qualified immunity even where he doesn't have probable cause for arrest, but a reasonable officer under the same set of facts would think he had arguable probable cause. Y'all remember the deep dive I did on Terry in my last couple videos? If you went on and you listened to the oral arguments on the Terry case, you'll remember multiple lawyers and even justices displaying a completely illiterate understanding of what probable cause actually means. And they created the doctrine of reasonable articulable suspicion out of the Terry case. And reasonable articulable suspicion is somewhat short of actual probable cause for arrest. Well, you know what else you have when you don't quite have probable cause? You have arguable probable cause, which is probably the same as having reasonable articulable suspicion. And the court doesn't want to take the heat for extending qualified immunity to include reasonable articulable suspicion, so they just made up a new thing that they called arguable probable cause as an excuse for giving officers qualified immunity where all they have is really reasonable articulable suspicion. And the degree to which that makes my fucking eyelids hurt just thinking about it is beyond my ability to articulate. I guess my issue with the constitutionality of the statute in question here is that if the encounter with the officer is pre-Terry, then it's consensual. That means a citizen doesn't have to participate because it's based on voluntary consent, which can be revoked at any time by the citizen, right? Well, if the citizen is detained pursuant to Terry, well, then they're in custody and they have a Fifth Amendment right not to self-incriminate, and that, to me, precludes any obligation on the part of the citizen to dispel the officer's suspicion. So the idea that a statute in Florida requires that a person self-incriminate in order to dispel an officer's suspicion, which, by the way, is, as we all know, impossible, it becomes obvious to me that it's unconstitutional. What's also obvious to me is that the cop on the left in this video is just a thug. If this was a scene from Menace to Society or Boys in the Hood, two of the excellent street gang movies made in the 1990s, the officer's conduct here would not be distinguishable in any way from any of the gang members characterized in those films. So my questions are these. How does this help the relationship between the public and the police? I mean, for better or worse, I am a person of principle. As a property owner, I can tell you with 100% confidence, I would rather have my property stolen or broken into than to give license to the police to use the fairy tale notion of protecting my property as an excuse to leverage the law to abuse citizens and literally tell people that if they don't like following the territorial rules of the gang here, then leave and move somewhere else. I'd honestly just rather be responsible for safeguarding my own stuff than to allow my property rights to be used in such a disgusting way. I never want myself or anything that I own to be used as an instrument to further oppression. Anyway, that's all for this one, guys. Please remember to like and subscribe and leave me a comment and let me know what you think about this case. Check out some of the other videos on the channel. Leave me a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.